Hi, I'm Andrew Meinzer of Meinzer Law Firm. Here we take care of people all across California who are planning to ensure that things go as they want when they die or become unable to take care of themselves anymore. The information that I'm about to provide is based on current California law. It's general information, it's not specific legal advice. Today I want to continue to talk with you a bit about the type of property of two people in a marriage or registered domestic partnership. This is the fourth and final video in a four-part video series. If you live in California, then you need to know about community property, quasi-community property, and separate property. That's true especially if you're married or in a registered domestic partnership. In the three prior videos, we talked about community property, quasi-community property, and separate property. And we also discussed changing the characterization of assets. In other words, changing assets from perhaps community property to separate property or vice versa. And we talked about mixed characterization assets. For example, assets that are partially community property and partially separate property. Here, we're going to discuss why all of that matters. Whether an asset is community property or separate property matters in various situations, and primarily in three situations. One, dividing assets at divorce or dissolution of marriage or registered domestic partnership. Two, payment of the debts and obligations of the spouses or registered domestic partners. And three, distribution of assets at death. The culmination of a divorce proceeding is a judgment ending the marriage, dividing the assets, and creating physical custody if there are minor children, etc. Each spouse keeps his or her separate property, and the spouses divide the community property equally between them. Community property assets generally are liable for the debts and obligations of each spouse. The separate property assets of each spouse are liable only for the debts and obligations of the owning spouse, but not the debts and obligations of the other spouse. And finally, transfers of assets on death. There's a lot to talk about with that, so we're going to do that in a whole video series, which will be our next video series coming up, talking about heirs. Who are your heirs in California? Planning ahead for transfer of assets after your death can be very complicated. There are many factors to consider, including who you want to receive the assets. Also consider how easy you want to make things for your family after you die. If you don't do this correctly, then you may create confusion and even conflict among family members after your death. Hiring an attorney experienced with California transfers of assets after death is critical for obtaining the results that you need. In addition, the advice and guidance of an attorney experienced with transfers of assets after death is invaluable in these cases. At Meinzer Law Firm PC, we have over 20 years of experience helping clients with transfers of assets in California. Again, I'm Andrew Meinzer of Meinzer Law Firm. If you know that you need our help with estate planning and transfers of assets at death, or even if you just have a question, please contact us and let us take care of you.